Yes. Very good. Well, good afternoon or evening, depending on where you are all, and welcome to this webinar on book writing and editing to mark the publication of the fourth edition of Wilmot-Smith on construction contracts. Depending on how your screen is laid out, he's just below me. I have form for saying that the speaker needs no introduction and then talking for 10 minutes. I promise I'm not going to do that because you don't want to hear from me, you want to hear from the panelists. But I am going to just say a few words of introduction about the books that our panel this evening have written. There are 4 panelists, but 3 books. First, Wilmot-Smith on construction contracts. The first edition was in 2006 and of course written by Richard Wilmot-Smith QC, one of the most eminent construction silks. It recently reached its 4th edition, which this event marks, with Richard now joined as author by Paul Darling QC, a man of like eminence. The book has an enthusiastic foreword from Lord Justice Coulson, who is editor-in-chief of the White Book, and himself the author of Coulson on Construction Adjudication, first published in 2008 and now also in its 4th edition. And lastly, on an allied but slightly different topic, we have the Rome 1 regulation on the law applicable to contractual obligations by Michael McParland QC. There may only be one edition of this book published in 2015, but it was described by Lord Briggs as a marvellous book and a magnificent achievement. All the panelists, before I hand over to them, are going to have to forgive me for starting by talking, however, about a completely different book. Because 2 of us, Paul Darling QC and me, had our first taste of book editing in the early 1990s, working on the 5th edition of Keating on Building Contracts, as it then was. And it seems to me, for this afternoon's purposes, that book is interesting and illustrative in this way. A young barrister called Donald Keating was asked to lecture to architects on the basic law of contract and tort, which they would need to understand in the process of contract administration. He had a problem. He had no textbook to use to teach them and to base his lectures around. There was a textbook on building contracts. It was Hudson, but that was massively out of date. So the young Donald Keating decided to write his own book. It went through 4 editions, was very successful, but then it too became out of date and was at risk of becoming the next Hudson, an out-of-date textbook. It was saved by the editorship of Anthony May and a team that included Paul and me, which, as I said, is how we first got our introduction to book writing and book editing. So that's the story of how that book came to be written and how it came to be updated. It kicks off, I think, our first question, or my first question to the panel, which is, what motivated you to write a book and to write a book on the topic that you chose? And I'm going to throw that question out first to Lord Justice Coulson.
Well, the honest answer to that question is flattery. I was sitting in my chambers not that long after I became a judge, doing whatever it is judges do, and the phone rang, and it was a woman from OUP who said she was doing market research into my area of the law and trying to find out if there were any areas of my area of the law that needed or could benefit from textbooks. So I said, well, the obvious answer is adjudication, because it's a new area of law and there are lots of cases and there's no textbook, and it's a really good opportunity for somebody to write a textbook and gather all the cases together. And she said, oh, well, a lot of people have said that. So I thought, well, why are you asking me? And then she said, and they've all said that you should write it. So obviously, as a result of this shameful flattery, I said, what a good idea. And I said yes. And that was before I became a High Court judge. And I was able to schedule the time. Rupert Jackson, who was my boss effectively in the TCC at the time, thought it was a very good idea. So he was very supportive. And so one summer, I sat down and wrote it. And obviously there were times during the writing of it when I wish I'd not been so easily flattered and so easily persuaded to do it. But it was because it was a good opportunity, and somebody said I should do it. So I took their hand off and did it.
Good. Mike, were you flattered into writing a book as well, or did it come about another way? And you're still on mute. No, still muted.
Still on mute, Michael.
Can you hear me now? Sorry.
There you go. There you go. How long has it been?
Sorry, how long's...
How long has it been since we've all been learning to do this?
Oh, I've forgotten. Life before Zoom conferences is just ancient history for me. There was a time we used to go to court. Do you remember that? And
I do.
stand in counsel's rows. Well, I was very happy to hear Lord Justice Coulson say that what motivated him was flattery, because that was exactly the same with me. I was rung up for my OUP. The only difference with my experience was twofold. One was drink. I had foolishly volunteered at a book launch party after a couple of baby shams and cocktail sausages to they asked me would I be interested in writing a book on choice of law in tort, and I'd written off a quick 15-minute synopsis, and then they rang me up and said, well, actually we've already got a book, choice of law in tort. Would you like to write a book on the Rome 1 regulation, choice and law of contract? And I must admit I was flattered by that. And that was I was a young man then, I was about 5, and the next 40 odd years were spent regretting being so easily impressed.
Yeah, that's interesting, because both of you have said that the subject area was identified for you by the publishers and to fill a space where there wasn't a text already. So Richard, I'm guessing that the position with your first edition was a bit different.
No, it was the same.
Yeah.
Rachel Mullally, the same editor at OUP, I hope is on this call. But I got 2 lunches out of it. First lunch was where she mentioned that, well, she asked me the question, was there a gap in the market? And I said, I thought there probably was. And I agreed then over a very good lunch to do it. But then I did nothing for 6 months. And then 2 things happened. First of all, I went to visit a friend near Beverley, and I stayed in a pub which had, you know, these pubs that have libraries. And I sat down to have a pint, and I just looked around, and there was the first, I kid you not, the first edition of Keating on building contracts in a pub. That's just part of the wallpaper. And I opened it up while I was waiting for the person I was meeting to come. And I thought, my God, this is how, you know, this is how they should be. It was just brilliantly written and very personal. It was like somebody had taken you to one side to tell you what construction law was all about, and you were absolutely riveted by it. And so I was. And so I then rang up Rachel, got another lunch out of it, and then actually agreed to do it.
I'm going to bring Paul in on the next question, but that's an interesting answer as well, because what you've just described is reading a book and seeing the personality come across from it and the clarity of writing come across from it. And I think you said it was like someone taking you to one side and saying, let me tell you all about construction law. So you obviously had to go through a process of then deciding how you yourself were going to take someone to one side, what topics you were going to cover, how you were going to structure the book. What did that process involve?
Basically being bullied slightly by Rachel for an outline, which gave me the discipline. So I segmented the task into 2. First of all, chapter headings, take them to one side. How would you structure the talk? What would you take first, second, third, fourth, fifth? is there a logic, and then are there the little rag bags? And then after that, then there were the subheadings within each chapter. But the first and essential thing was each chapter heading. Each chapter. And then you come to the subheadings within each chapter.
Is everyone else's experience similar, or did you go about things in a different way?
Yeah, I approached it like a judgment. I sat down, I wrote out my outline for the chapters, and then I wrote out the subheadings within the chapters exactly like that, and then fired up the dictating machine in the hope that it also sounded like somebody taking somebody aside and telling them about adjudication.
Mm-hmm. Mm-hmm.
And hoping that they didn't nod off partway through, obviously.
Very unlikely, Peter, very unlikely. Mike, same approach, or did it involve a dictaphone? That's a blast from the past.
I've only ever used that once. I remember once, Lord Justice Coulson and I shared a pupil master who used a dictaphone all the time, but I only ever used it once in my life. But no, I had to use my fingers, unfortunately. For me, the situation was rather different in that I was talking about a regulation of which there was no case law. It was just come into force. The background was probably obviously the convention in 1980 and that. So I had to think long and hard as to, well, what do I want to, what I want to give to people? And the conclusion I reached is, what I want is a book that enables me as a practitioner to have at my fingertips what I might need to know if I need to construe this regulation on a Friday night. So I spent a lot of time digging up all the travaux preparatoires from unreported negotiations in the Rome I committee in Brussels as to the discussions of what should go in the text. So that took me a lot of time. So that was the difference. I had to decide, well, how am I going to approach this? And the answer was, I'm going to create a complete record of the evolution of this regulation and then project forward as to what I think is likely to be the interpretation given to it. Took me a long time to work that out, and Rachel Mullally, God bless her, was very patient with me, because without her it would never have got off the ground. Because I think one lesson I learned as a practitioner entering into a private international law field is that's the realm of academics, that's their pitch. And so when you put in your proposal, as Richard did, the academics will look at it and they'll come back. And while the practitioners were supportive of the proposed book, the academics, their responses were sort of, I don't know Michael McParland, I've seen he's been in some cases, I don't wish to be rude, but he's a barrister, so he's probably barely literate. It was that sort of reaction to it. So thanks to Rachel for keeping on the straight and narrow.
That again, what I think you've picked up on that is that you saw yourself writing a book for practitioners.
Yes.
Taking the book into court, as you say, it's a late Friday, you're in court on Monday, what do I need to know? I think I haven't given, it's extraordinary. I've managed to keep Paul Darling quiet for about 15 minutes. I don't think I've ever achieved that before. But I think I'll throw the next question there for Paul, which is when you became involved in Wilmot-Smith on construction contracts with Richard, what was the discussion between you? Is this a book for practitioners? Did you see it that way, or did you see it as an academic treatise? What was your approach?
Well, first thing is he just said get it updated. Was the first.
There you go, then.
But I think we see it very much as a textbook for practitioners and those who want to be directed to the right starting place to look at these areas of law. We don't regard it as a academic treatise, and it is also intended to be starting in many places from scratch rather than evolved over many editions. So I think it's meant to be, I think, very much what Peter was describing for his book and what Michael was describing for his as well.
Okay. Well, you've led to the next obvious topic, which is the book's written, and it's, as I said before at the beginning, with something like Hudson or Keating, it's in danger of going out of date because the law keeps changing. I mean, these pesky judges keep deciding cases, and Parliament keeps passing new legislation. I mean, how inconsiderate. So you've got to have another go at it. Do you feel you've got to have another go at it, or could you just say I've written the perfect tome on this subject, and I'm going to leave it be now. Do you feel obliged to update it for your reading public? Peter, let's start with you again.
Yes. You obviously you have to. You can't keep updating it, so you have to choose a sort of reasonable period of time to go by, but you do have to keep updating it because the law changes, and sometimes people say that you've got it wrong or that the judge has got it wrong, amazing though that may sound. And so what you've said in the first edition as to the law is then said by the Court of Appeal or the Supreme Court to be wrong. So you have to then delete reference to that case or explain that that case has been overturned as a result of some other decision. So you do have to update it. And that is the one thing that I would say to anybody who's thinking about writing that, and I would encourage everybody to do it, but it is the one thing that I would say to people: don't underestimate the amount of work that's involved in updating a textbook, because especially one that you're aiming at practitioners, because there are textbooks out there, and we've all seen them, which you can tell what they've done in the updating. It's the same, it's exactly the same text, and then there's a few paragraphs stitched on to the end. And I am conscious that that is a criticism which you could level at one or two bits of the white book. And that's just not a helpful way to do it. But what it does mean is that an update can involve, depending on how much change there's been, a major rewrite. And there have been times when I have thought, oh, great, I've just got to update the book. That won't take very long. And that is a bad attitude, because it bloody well does. If you're going to do it properly. I don't know if Richard's experience is the same. I mean, he went to the drastic straits of inviting Paul. So he must also regard updating as a hard task. But certainly that's what I've found. It is very rewarding, because once you've done it, it is there, and it is, perfect for them. But it's much harder work than anybody tells you.
It is.
Before Richard answers that question, before you answer it, you will get a chance in a minute.
Sorry.
I've got a direct question, Peter, for you, which is there a fifth edition in the pipeline?
I think there needs to be a fifth edition, and I would hope that if I was asked by OUP, I would hope to do that next year. Now I'm no longer Deputy Head of Civil Justice. I have got some time that I otherwise spent doing that. So it is quite a good time to do it. And a lot has changed since 2017 when I wrote it.
Thank you.
So the short answer is yes. Boo.
Well, it's a flattering question to be asked, I think. So Richard, I stopped you answering Peter's question, which was, did you agree with him? What hard work it was and how much rewriting was required?
It is hard work, and a huge amount of rewriting. I think it was the first lunch with Rachel. We discussed the competition, and one of the problems with the competition was that each chapter gained new updates by way of what appeared to me to be barnacles. You just shove a new case in until the character of the original disappeared. And one of the purposes of the book was to make sure that it had a character, like the person taking you to one side. The two types of updating, or two stages of updating. The first is the mere assembly of the new cases. But the second isn't just the bolting on of those new cases, but it's standing back and looking and saying, well, actually, I've got to rip up what happened originally and change it and rewrite it completely. And the most obvious example, I think, between the first and the second edition, or between the second and the third, I forget which, was taught. That initial book or chapter.
Sorry, David.
Sorry, where are we? Oh, sorry, that just disappeared completely. And the fourth edition is by and large altogether rewritten. But it's two stages. You've got to do the base work of, well, what has happened, and then you stand back and you see the big picture and you realize, well, actually what happened is it isn't a bolt-on, it's a rewrite.
What parts of the, well, you said it's almost a complete rewrite, but are there certain sections where you think either you've revisited what you wrote and felt it needed rewriting, or the laws changed so much that you felt it needed rewriting?
Both. Sometimes I just got a little bit too wordy. Sometimes you could, when you stand back after a couple of years, you realize, actually, I shouldn't say it, but the errors you've made, not necessarily of substance, but of style or of direction. And you think, or even the way the case is looked at, how you categorize it and how you order it. And you think, no, I've got to start again.
And I think I'm going to ask Paul a question in a second on the back of that. But before I do, there's another question that's come up in the Q&A, which seems appropriate at this point, Richard, which is, what part of the book are you most proud of?
Oh, the one I didn't write, the one my son wrote. The one on unjust enrichment. Paul can say how good that is.
Oh, marvellous. Absolutely marvellous.
So what I was going to ask you, Paul, was which bit did Richard let you loose on?
Well, most of it. No, we had help from, it was very much a collaborative exercise. Firstly, by getting some mechanical work done to check which cases have been commented on, cited, etc., etc. And then we had a team per chapter, looking at it, talking about it, then editing it, then it going through three different filters. By the end felt like an awful lot, but it did mean that we kept the style of the book. What it meant was that some people, and when you have a number of people involved, keeping the style and the quality right is A, difficult, but B, very important. We ended up with some chapters that needed much more work than others. Anyone who wants to do a minute textual analysis could look at the chapter on bribery, which I was solely responsible for. And I think there are 3 changes. It may be more than that, but and one of those was suggested by Richard in his rewrite. Whereas, for example, chapter 8, just looking at it, mistake, misrepresentation, and frustration had a bigger rewrite than others. So I think. But we basically, Richard and I ran the coordination together, and as deadlines approached, we ended up ensuring that. Between us, we read them all, worked on them all, and then moved them back between us.
I think we were in panic mode most of the time.
In other words, Richard gave you the section on antiquities clauses.
Yeah.
But it is. I mean, Richard's right. We all know that with other books, we have to avoid it for this one. But the original author had a style and an approach. And you've got to be very careful that you try and hang on to that style and approach as you evolve and as other people help you with it. And I think I think we've not done too badly on that. Though I think inevitably, when you are doing the rewrite element and not just the update element, there's more scope for that to get variable. And we're very conscious of that, weren't we?
You've got a big team working on the book, so that keeping consistency in not just quality but style must be really challenging. Did you work by having a style guide, or did you?
Well, we did in the end.
You did by the end. You
Yes.
worked out what the style was by the end.
Well, we worked out the fact that we needed one by the end, but of course, like all these things, deadlines come. Now, the way we did it was we had a 4-level approach. Level 1 was the mechanical checking of the cases and the statutes and the articles. Level 2 was a junior member of Chambers, much in the way that the 6 in Keating did at the start, went through looking at what might be done. Level 3 was then it being edited according to the style. And then level 4 was essentially me and Richard going back through it. So we had that process. I mean, like all these things, now I've done it once, I'll know how to do it next time. And I think that the pitfalls, one also learns, the pitfalls are that somebody takes a look at it and decides that they want to rewrite a bit and it doesn't stand out with the rest. But we were very lucky that our level 4 process, I think, worked very nicely. I mean, Richard, I don't know whether you think I'm overstating it, but I think we did manage that. Others will judge how much we succeeded. I think we went through the right process.
I think we went through the right process, but we were actually very lucky with the quality of the people who were doing it. I mean, it's just remarkable, actually.
I mean, one thing I put this question to both of you because it's an experience that I had, or would have had to some extent, when we continued editing Keating, which was how to direct the research that was going to be done in order to feed into the 4-stage process that you've just identified. And there are different ways of doing it. There's a wholly mechanical approach, which is just to say, look up every case and see if it's been referred to anywhere. And then there's a rather more engaged approach, which is to follow through the cases and see what the updates may be. Did you direct your teams in that way, or in one of those ways?
There were 3
to get their input.
I was about to talk over you again, and I was awaiting my admonishment.
You're not allowed to do that.
Yes. There were three techniques. One was the mechanical one, which, when Keating was done in the 5th edition, involved going through physically the law reports indices, now obviously capable of being done online. Second, and this was an exercise I did myself, I went through every ConLR case, every BLR case, and 1 or 2 other publications since the 3rd edition was published, and categorized them by chapter, and therefore gave direction to those who are going to be involved. And thirdly, we then had discussions with everyone involved in each chapter about the direction it might take. And you did find, it was very interesting, you found lots of cases in the BLRs that hadn't been thrown up by the mechanical exercise of looking at what's been referred to and what had been identified. And I also found, cards on table face up, I found it personally, going through 6 years of BLR and ConLR, 7 years, whatever number it was, very interesting and revealing, because actually when you do that, you see the trends, you see the personalities, you see the way in which the cases evolve. Partly, interestingly enough, directed by the selection of cases by those who edit ConLR and those who edit BLR, but certainly, and that then helped you to feed into the team. And of course, because of track changes, you're able to look at the alterations that then you make or that they make, so that at the end, you were able to do a comparison. What we did was we did track changes and then accepted all, and then went back to compare right. So you could then actually have the two side by side and see exactly what you'd done. And I think that worked quite nicely.
But Paul, just picking up on that, I mean, that is one of the things that, I mean, it's trite to say that if you write a book about a subject, you learn a lot, but you do, and you learn, obviously, hopefully, you know that there's basic areas, but you do come across cases both in when you're doing it originally and then when you're doing the updates. And sometimes when you're doing the updates, a case is brought to your attention that actually was some years ago that you've simply never seen before.
Yeah, I agree.
And in adjudication, this happens particularly with Scottish cases, because some of their cases have been very important, and you do learn, you discover something that you simply didn't know, and certainly in my case, that's quite a common experience, but also a very useful one.
Yeah. Mike, I said at the beginning, your book has 1 edition so far, so you haven't been through this process. Are you planning on doing it? And if you do you think you'll do it on your own, or surround yourself with a team of enthusiastic young members of chambers or whoever, or Paul. I'm sure Paul's available.
Well, I was asked to do it again a couple of years ago, but events have kind of conspired against us. I must admit, it's the pandemic and Brexit caused. I was going to wait till obviously what was going to happen. As you know, the Rome 1 regulation has been kept as part of this special retained EU law. But the reality is, my book is 900 pages. That's half the length of the original draft. And so I have piles of stuff that I accumulated that at the time I thought when I did this massive edit may not be relevant. But now we've left the EU and these historical travaux preparatoires issues may become more relevant because we won't have access to those materials in the same way. And at the time when I wrote it, of course, they hadn't even defined what a contractual obligation was for the purposes of the regulation. So I have been keeping up to date. But I think the reality is, sometimes you look back at a book and you think, well, this chapter, I just need to come in a different way and or improve the way people react to it. Now, on the question, one example was when you haven't made a choice of law. When they had the Rome Convention in 1980, they had used this method of asking, well, who's the characteristic performer of this contract? And what's the characteristic performance? Which was a Swiss law concept. So being a nutter, I went and researched all the Swiss law background to all this and how it had been imported into all this. And I was really proud of these about 20 pages about how all this involved Swiss law and how they made a complete pig's ear of this, that, and the other, and how it had been adopted in the Rome Convention. And then when a German reviewer of the book, who was very favorable to the book, said, well, there isn't very much on characteristic performance. And I realized actually in the index, this section wasn't marked up. I hadn't spotted that. There was also things you can come back and you want to check because you think, God, I spent ages looking at all that Swiss stuff and you haven't even read it. So there are things that you want to improve. I will do it because I think you owe it to yourself in a way and to your people who have used it. It's one of the great, and I'm sure everyone who's written a book, is one of the great things is when you see it cited with approval in the Supreme Court or the Advocate General's referring to the European Court. In my case, I'm chuffed to bits. You actually feel that's great.
Do you keep a sort of little record as you go of things as they happen? I
go back periodically. I would go back to say the CGU cases every month and see what the cases are on Rome 1, Rome 2, and the main source of data for Rome 1, of course, will be the Brussels regulation, because that's the contractual matters relating to contract will be applied effectively by analogy, the factual circumstances there.
Because one of the things that I'm thinking of doing for the next edition is, and I think it's a consequence of the way the world has changed, because we always see the law reports online and in the Law Tell, as they used to be, of blessed memory, daily updates, because we used to see, we're used to seeing all of that and hearing about cases in real time, as it were. One doesn't necessarily go back to the reports when the monthly or weekly parts appear, and I think that that's something to be encouraged. The late great Donald Keating used to keep a card index next to his desk, and I think I'm going to try and adopt for the next edition the sort of a virtual card index.
Do you think, though, it's possibly slightly moving away from the topic, but you've identified, Paul, going back through particular reports, and you were saying a moment ago you can see trends in the law being affected in part by the way the reporters have selected the cases that they're going to put into those. At the same time, we've got, as you say, the almost real-time reporting, virtually everything on Bailey or Law Tell as it was, or Westlaw as it is now. Do you think we're sometimes overwhelmed by every case being reported as if it's got some great point of law in it, when half the time, and I can tell you quite frankly from this side of the bench, that you think all you've done is apply a perfectly standard principle and the case is of no interest to anyone apart from the parties, obviously, and you're suddenly asked to approve the transcript of it as if it's regarded as some considerable import. From the perspective generally, but also from the perspective of updating texts, do you feel we're potentially overwhelmed by the case law?
I'm absolutely sure we are. I think that that for me, I went and did, because it was easier and quieter, and I've felt academic and intellectual. I went and sat in the Inn's library to go through the BLRs and the ConLRs, and I think one's got to accept that with the editors of those publications, there is an element of personal quirkiness, and there is some selections that are to do with the identity of the editors and their interests, but it doesn't affect the overall thrust, which is that you get the more important cases, and also with headnotes. So you're able to think more strategically about it than if you're just getting the Lawtell, Westlaw, Bailey approach. And I think you do get a real sense of, you know, also the volume of case on particular topics. You'd see phrases when there were adjudication was, you know, the absolute rage for 6 months, and then suddenly you see a pause and cases about mistake. Really quite interesting to see how it all plays through.
See,
There's a question. Sorry.
In my area, it's often keeping up with the academic writings, which is fine in English law, but there's an awful lot of written on the continent, which if you ever can't get help sleeping through ordinary medication methods, then reading some of these, having these journals next to your bed. I did remember, and when you're writing a book, I'd advise anybody, there's a moment where you think you're definitely going mad. And I remember thinking, walking down the street, oh gosh, I'm glad I remembered that article in that German journal by that Italian law professor, which I downloaded last year. And I thought, no, Michael, it's time to go to the pub. This is, you're reaching overload capacity here. So that's the hard bit.
But the sort of books that we've all been doing do give you overload, because that's one of the reasons why having the team that we've had at 39 helping us with Wilmot-Smith, because as you say, you are walking down the street and all you are thinking about is, have I got the interchange between force majeure and frustration right? Have I got the sort of spin on that? Have I missed anything? You know, that is you do get into mental overload. I mean, I have to say I'm slightly jealous of you and Peter, because you know your topics are so specialist and confined. For example, when we're looking at Wilmot-Smith, we've got a whole chapter on assignment, and you know, some poor person has to update the chapter on assignment whilst thinking about, you know, in the law generally, and that's quite an ask, because it involves not just our area of the world, but nevertheless, you know, cases throughout the world and throughout the divisions on that abstruse subject.
The problem you're talking about, the problem you were talking about with updating, I think, has been true for a long time. It was less of a problem in the first and second edition, because, dare I say it, the TCC was incoherent, and you had to.
Before Peter's time, I hope.
Sorry, what?
Before Peter's time.
No, and it was when Rupert came and took it over, and if you notice his judgments in virtually any case, the principles are as follows. And what he was doing was codifying and directing the judges below him to make sure that there was clarity. And so for me, it was easier in the first edition and the second edition, because I had to take my lead from Rupert, who was gathering together the Tower of Babel and promulgating it. Now it's the problem you're talking about when you say, well, is this something new, and query whether it is or it isn't.
And that's made, sorry.
No, I was going to say that there's a question that's come up, which is that there's another one which I'll come back to in a minute, but there's a question that's come up in the Q&A which is quite pertinent to this topic, which is whether there's a particular difficulty, and I think Paul and Richard, this applies to your book more than it does to Mike and Peter's, in identifying non-construction related case law that impacts on what you're talking about and needs to be taken account of in the updating process, because that takes you outside just looking at specialist law reports or what's been decided in the TCC, and takes you into all sorts of other areas, not even necessarily just the commercial court. How do you go about it, or how did you go about addressing that sort of issue?
Well, you're looking for the cases that the editing process of seeing what's been commented on has not picked up. So if it's been picked up by the editing process, you get a bit of a clue. But I regard it as my responsibility and that of those helping with particular chapters, editing particular chapters or whatever role they were taking, to look at these topics in other textbooks to get a feel for what is being dealt with. And that's one of the things I found personally so rewarding is, you know, when we were doing McAlpine and Panatown and all those cases, I knew all about the law of assignment and no loss because I was dealing with it every day. Being able to get back into those areas of law when you don't actually need them, I thought was particularly beneficial. And it's right that, you know, you look at, less so in the construction field, but my familiarity with the sort of tone of contracts came very much from looking at treaty and things like that, which I think helps you to cross-fertilize. You obviously form your own view, but it sends you in the right direction.
Yeah, and if you want to, for example, know about liquidated damages deeply, do a deep dive on a difficult question, you could do worse than look at Scrutton on charter parties, because liquidated damages demurrage very, you know.
Well, Richard, that's a very controversial thing to say. That the Supreme Court will shortly, I suspect, discuss the link between those two when it considers the appeal in a case called Triple Point, in which our chairman was the trial judge, in which I didn't appear in front of her, but where the Supreme Court is currently considering its judgment, and we anxiously await its outcome.
And in which, as I say, at every possible opportunity, the issue on liquidated damages wasn't pleaded and wasn't argued before me.
No, and it led to a marvellous interchange between me and Lord Leggett, where he said, if this point was so obvious, Mr. Darling, why wasn't it raised in front of the judge? And I explained that there was a dynamic in the Court of Appeal and the judge in the Court of Appeal. And indeed, that one of the reasons that I was now involved was because this point had been brought up in the Court of Appeal, and it was thought that my construction law experience might be of help. It led to me being put very charmingly in my place by our opponent, James Howells, who said that he'd been in throughout because he had some expertise from the beginning, which I thought was a very charming way of putting me in my place. But that topic, that's quite an interesting illustration, because in that case, and it's quite right that the point wasn't argued in front of the trial judge, and it was invited to be argued by the Court of Appeal. We did then dive around jurisdictions, both in the UK and in America. And I think that when you find out about a point of this sort of book gives you the chance, not just the Supreme Court, to do that sort of exercise. And that's why having your team resourced by this big team of enthusiastic and clever people is one of the keys to getting the basis done.
Okay. There was a question I said I was going to come back to. I'm going to ask in a slightly different way from the way it's been posed in the Q&A, but well, books are all hardback books. Any enthusiasm for publishing them in paperback, or not so people can read them on the tube, but so that they're more accessible price-wise, if nothing else, to a different readership, particularly a student readership?
Well, you, of course, have given me the in to the commercial, which is that everyone attending today will be getting the opportunity to buy the book at a 30% discount. Some might say that the extra discount is scant compensation for having to listen to us, but nevertheless, everyone who signed up, let alone attended. But you're still talking about a book that is, even with that discount, on our case, going to be around the £200 mark. I'm going to give copies of it, or give copies to my old college at Oxford, so that at least one student will see it. I think that there's a lot in this that would benefit from the wider market. I think that obviously we're much, much cheaper than many other equivalent books. There are some, without naming names or naming numbers. I decided to buy copies of various of them, and thought a nought had been put on the end by accident. But I think that wider accessibility is good. I think that the need for the online bit, particularly for the young, is maybe one of the ways to do it, and subscriptions. But certainly, I do think it obviously we would say this, wouldn't we? But all three of our books would benefit from a wider audience, and that people, whether they're doing academic stuff on construction law or on contract generally, would get something out of it.
Publishers don't seem very keen, though, on lowering the prices. I'm afraid, because there isn't a huge market in our field.
No, and also we all know that these are expensive things to produce, because you have to have an editor, you have to have once you get it to the publisher, you've then got all of this toing and froing, correcting it, proofreading it, formatting it, cross-referencing it, which I have to say was for me one of the big surprises as to how time-consuming and difficult cross-referencing is. I'm not a man who's known for cross-references normally, but I'm afraid I had to be this time.
Yeah, I think it's very easy, isn't it, to underestimate quite how much work, not just in the writing of it, but the production of books of this nature involves. I can tell you, though, Mr. Darling, that one of your instructing solicitors is concerned, to put it lightly, that you didn't bother to tell him he could get a discount before he went out and bought the book at full price.
Yes, there are. I have had a couple of calls to that effect, and I'm going to have to buy some very nice lunches so as to compensate those who indeed. I've had a couple of sort of emails that describe them as tart would be slightly harsh, but certainly you can see that and indeed. It's worse than that. Someone I know has had a present made to him of one of these books, which, as he said, was a little bit late.
There you go. Well, I think we said we would run for about 45 minutes, and we're now at 50. So would any of you like to share with us a final piece of wisdom or experience before we wind up our session?
Well, could I just say one slightly emotional thing? Forgive me, if I'd be allowed to. I'm very grateful, obviously.
You haven't won an award yet, mate.
No.
I mean, when you do it, you can thank the little people, but until you get there.
No, I'm not thanking. I'm very grateful to everyone, obviously, but obviously it's great to have had this seminar with Neris, Michael and Peter, but I wanted just, if I could, to say a word about Richard and say how grateful I am to him having invited me to be involved in it. When I arrived as his pupil in 1984 in 22 old buildings, little did I realize that in 2021 I would be editing a book with him. It's been an absolute joy. Well, a joy most of the time, always a joy with him, but nevertheless a complicated process. And I just wanted to say how grateful I am to him for having involved me in it.
Oh, you're very sweet, Paul, and I'll get emotional too. It's been a privilege having you.
Thank you all very much. It is the point, Richard, of our webinar was to mark the publication of the fourth edition. I think you shared with us a lot about how the book came to be and how personal it is, and that's a very personal note to end on. Thank you all, Lord Justice Coulson, Paul Darling QC, Richard Wilmot-Smith QC, Michael McParland QC, for your fascinating insight into how you've gone about producing 3 fantastic books. 30% only available off Wilmot-Smith on construction contracts at the moment. Get your copy as soon as possible, and thank you all very much for your participation.
Thanks very much.
Bye-bye. Thank you very much.
Bye-bye.